My name is John P.L.C. I'm a probate litigation attorney in Florida with the P.L.C. law firm. We're based in West Palm Beach, and we handle litigation, lawsuits, and appeals for matters involving wills, trusts, estates, guardianships, and business and commercial litigation. I'm going to be speaking to you now about a Florida probate litigation topic regarding evidence and getting documents into evidence in your will contest or your trust lawsuit or your guardianship trial for that matter. And the reason I'm doing that is on April 8th of 2016, Florida's 5th District Court of Appeal issued an opinion in the Diaz case. And that had a number of issues related to evidence that, while the Diaz case was not a probate case, those principles are applicable if you are involved in a will contest or a petition to revoke probate or tortious interference with an inheritance case in Florida, or also if you're a Florida probate attorney or a trust lawyer in Florida and you find yourself going to court more and more for evidentiary hearings. So we know in the probate context, when there's a will contest or a trust lawsuit, many times people want to get documents into evidence. If there's an undue influence or dementia case, you may or may not be able to get the decedent's medical records into evidence, or nursing home notes, or a diagnosis, or doctor's notes, to demonstrate mental state, to demonstrate whether somebody was susceptible to undue influence, or whether they lacked the capacity to sign a will. We're incapable of knowing that they changed an estate plan or a trust or a will in Florida. You may also want to get financial records in financial abuse cases, elder abuse cases regarding property and money. Whether you're in the guardianship context, such as if somebody's incapacitated or not competent, such as if they have dementia, or after that person passes away in the probate litigation context. You may want to get financial records such as bank statements or brokerage accounts in to demonstrate that money left a particular account and went to somebody who misused it or didn't use it for the benefit of the person they were supposed to. So, how do you get documents into evidence in a probate trial in Florida? Well, I'm going to leave you with 4 thoughts regarding that, because many Florida probate attorneys and many estate lawyers don't know how to get documents into evidence. They incorrectly believe that they can just get up and argue. That's incorrect. Argument of counsel is never evidence in Florida, and at the end of the day, you are going to want the trial judge, the probate court judge, to make findings of fact and conclusions of law. To make findings of fact, you need evidence. Evidence is not your Florida estate lawyer or trust lawyer making an argument from the podium in the middle of court. Evidence is introducing documents, calling witnesses, having testimony received by the court, relevant and admissible, so that the court can look at that, draw its own inferences, come to its own conclusions, and make findings of fact. You cannot just show up into court and say, here are medical records or here are bank statements and let's consider them. You actually have to move them into evidence, and you should expect that there may or may not be a hearsay or other objection from trial counsel. So you just can't hand documents to the judge and hope that they get in. You have to move them into evidence. And if the other side will not stipulate to their admissibility or their authenticity, right, and there's a difference. The other side, the other Florida trust litigator, may admit or stipulate to the authenticity of the documents, but if he or she doesn't know how you're going to use those documents, they may or may not agree to their admissibility. So if the other trial lawyer who's handling the estate or guardianship or trust lawsuit in Florida does not agree to the admissibility of those documents, it's your job to get those documents into evidence. And I'm going to leave you with 4 important rules for getting documents into evidence in your Florida inheritance lawsuit or probate contest. 1, first of all, understand that the trial court has great discretion in determining the admissibility of evidence. That's an awesome power that's granted to our trial judges, and you should be able to concisely say why a document should get into evidence and then state the basis that supports that. 2, The general standard for a trial court judge in Florida committing an error regarding evidence is an abuse of discretion standard. So understand that absent an abuse of discretion, an evidentiary ruling by a probate court judge at a will contest or inheritance trial in Florida is not going to be overturned. You should know what that abuse of discretion standard is before you try to get documents into evidence if you suspect they're going to be objected to. And you should be able to define what that abuse of discretion standard is for probate evidence issues. The third topic that I'm going to, or point that I'm going to discuss with you, is to get those documents into evidence, you need to lay a foundation. That typically means that you need to call a witness who is going to testify based on personal knowledge that the documents which you want to get into evidence are what they say they are, that they are credible, that they're accurate, and also relevant. Now we know that relevance is framed by the pleadings. So you generally can't get documents into evidence if they have nothing to do what's alleged in the complaint or in the answer of the affirmative defense or any counterclaims or counterpetitions. Remember, relevance is the backbone of evidence in Florida probate trials, right? Many Florida probate attorneys are very well versed in the Florida probate rules, the Florida probate code, but when it comes to Florida Chapter 90, the rules on evidence or the rules of procedure, perhaps not as much. As a Florida trust litigator or a guardianship litigation attorney in Florida, you do need to know all those matters. So after relevance, you need a foundation to get those documents into evidence. And if you're talking about business records, or you're talking about the business records exception to the hearsay rule in the probate court context, understand that you don't need necessarily the person who actually prepared the records to testify on the stand. This is an important part of the business records exception to the hearsay rule when you want to get medical records into evidence in a will contest or bank records in a guardianship case or financial exploitation case or a breach of trust case, such as in the case of where a trustee may have misspent money or used trust funds improperly. So you do have to call a witness who's well acquainted with the activity of those records to give testimony. Okay, so very clear that while it would be ideal to call as a witness to lay a proper foundation to get documents into evidence in a probate trial, it would be great to call that witness who actually prepared the records. That's not necessary. If you want to read a little bit more about these evidentiary issues, the Diaz case was issued by the 5th District on April 8, 2016. The appellate court number is 5D, 5th District, 15, 2015 case, 1612. This concludes my remarks about evidentiary issues and getting documents into evidence in Florida probate litigation.